morning, Mr. Abbott.
Good morning, Chief Justice Marshall. Members of the court, my name is David Abbott, and I am here today representing the appellants. With me is my colleague, Andrew Berman. This appeal arises out of the plaintiff appellant's challenge to the validity of a zoning amendment enacted by the town of Kingston in 2007 pursuant to Chapter 40R, which is the so-called Smart Growth Statute enacted by the legislature in 2004. For purposes that I'm sure we'll get to later, I think it's important to emphasize that one of the purposes of Chapter 40R, as articulated by the legislature, is the encouragement of production of housing and land development, while at the same time preserving areas in the Commonwealth of critical environmental concern. Now, unlike other zoning amendments enacted pursuant to the Chapter 40A, the zoning enabling statute, there's a particular procedure which municipalities must follow to adopt and enact a zoning amendment under Chapter 40R. And that procedure, briefly, is as follows. The municipality must complete and file with the Department of Housing and Community Development an application for approval of a smart growth zoning district. The legislature and
I have a question, Mr. Abbott. What is exactly the role of DCHD? Are they supposed to review everything, including disruption to the wildlife, or is wildlife disruption best left to the Department of Wildlife and Fisheries? I mean,
well, Your Honor, I think that the legislature was very specific in Chapter 40R as to what the requirements of a smart growth zoning application must contain. DHCD has gone further and added even more specificity to the requirements of that application. One of the issues in the application is how much land is within this district that can be developable. The legislature said that that developable land cannot include areas of critical environmental concern. DHCD has specified that that includes wetlands, steep slopes, or I'm sorry, not steep slopes, wetlands, and also areas that have been designated as rare species habitat. Now, the importance of that, Justice Cowan, is, among other things, is that it helps DHCD determine whether the proposed zoning district is in accordance with the statutory purpose of promoting land development while preserving areas of critical environmental concern. And there's also a very other important...
well, DCHD is not challenging this.
You're right, Your Honor.
Yeah, so they apparently are satisfied that this falls within the parameters of a project that is properly within the smart growth.
Well, actually, Justice Cordy, on that I would respectfully disagree. The problem there is we don't know what DHCD would do if it was given.
But won't it get it in the annual updates?
That's a very good question, Justice Botsford. We have an annual update that was filed in 2007, part of the record, that did not update the developable land.
Okay, but now it's 2010.
We also have, as part of the record, Your Honor, the annual update filed by the town in 2008, also not updating the developable land. So, Your Honor, we're talking about a change to developable land that went into effect on October 1st, 2006. The town of Kingston was under a duty to supplement, and I'm happy to go into that in detail as to whence that duty arose. But the change occurred in October 1st, 2006. In the annual update in 2007, the change was not brought to the attention of DHCD. In the annual update in 2008, it was not brought to the attention of DHCD, and that's where the record stops.
And how go ahead.
Yes.
Now, how is this important? Is this piece of land where there's now a rare species, does that mean that somehow this parcel of land around a rail station somehow falls within below a minimum, statutory minimum for zoning purposes?
Your Honor, it doesn't. To my knowledge, it doesn't fall below a statutory minimum. On the other hand, the legislature has directed that zoning districts enacted pursuant to Chapter 40R must not compromise areas of critical environmental concern.
Well, won't that be a permitting issue with respect to very specific projects going in this area?
Your Honor, it will be a permitting issue. However, the legislature and DHCD has made it a zoning issue as well.
But if it doesn't fall below a statutory minimum,
yes.
Isn't that the answer?
No, Your Honor. I think that, first of all, in addition to whether it still is a, quote, eligible location under the purposes of the regulations, there's also an issue of whether it furthers the purpose of Chapter 40R, which is preserving the areas of environmental concern. One other thing that we haven't got to, Your Honor, is that One of the reasons why DHCD has this very detailed application, which the towns must fill out accurately, is because one of the results of receiving approval as a 40R district is that the municipality receives money from the Commonwealth.
Okay, but you haven't made DHCD a party here. You're not challenging their findings. You're not saying that there's no rational basis for them to proceed. You're saying that the town itself, that the town's passage of this zoning amendment should be declared by a court to be invalid.
Absolutely, Your Honor, because, for two reasons, and it's focusing on DHCD as the first reason. In order to enact a zoning amendment under Chapter 40R, the town must receive the pre-approval of DHCD. That pre-approval is issued pursuant to DHCD's review of the application, the specific requirements of which were established first by the legislature, then by DHCD. The application in this case was materially incorrect with respect to a very important issue, which is how much developable land is within this 106-acre district. Now, as a result of its approval, on the basis of the materially incorrect application, the town of Kingston's received $600,000, which it's still holding. Now, that $600,000 payment from the Commonwealth was based on Kingston's representations that approximately 70 acres of the district constituted developable land. Now, in fact, that wasn't the case. We think that the record reflects that the town of Kingston may well not have been entitled to $600,000. DHCD waits for Kingston and the other municipalities to provide the information. Under the regulations, all DHCD is reviews the information that's provided to it. Okay, in this case, Kingston hasn't provided the information necessary for DHCD to give a complete review.
But what is the principle here? The principle is that the Supreme Judicial Court, when a party comes before it and says that a town passed a zoning amendment based on incomplete or arguably inaccurate information, should declare the amendment to be invalid, and we should basically say the selectmen of Kingston didn't have all the information, therefore we're going to invalidate the amendment. If we were to do that, I would think that many amendments would be at risk, because somebody could come forward and says there was an omission or there was some misinformation furnished to the selectmen or to the city council.
Justice Gantz, the plaintiffs do raise two arguments on appeal. The first is that the town, when it voted for the adoption of the amendment on April 11th, 2007, had given no consideration whatsoever to the effect of the habitat designation, which meant that approximately 50% of this zoning district, the purpose of which is to foster dense, highly dense housing in the vicinity of the commuter rail station, that the town was not aware, hadn't given any consideration whatsoever to the effect of that designation. And the record is clear that no such consideration was given. So that goes to the issue of whether the town engaged in sufficient planning, due diligence, consideration of sound land use planning principles, because what we have here is the town didn't give any consideration whatsoever to the effect of the October 1st, 2006 designation before voting. Secondly, Your Honor, unlike your typical, your usual Chapter 40A zoning amendment, Chapter 40R zoning amendments can only be adopted after they've received state approval, in this case from DHCD. And what we're saying here is that that approval was given on the basis of a materially incorrect implication. And with respect to whether the town had a duty to supplement its application after filing it, that duty arose in at least 4 different places.
I'm confused about if any development will need permitting. You've got however much money you said, $600,000?
That's right, Your Honor.
What's the problem right now? There's no. Have any permit applications been made? Has any development been started?
It's not in the record, Your Honor. However, an application for, I think, a master permit has been applied for and granted by the town of Kingston, yes. But no specific building permit applications have been filed, to my knowledge.
And there's no minimum developable lot, as Justice Cowan asked, and DHCD isn't a party. I'm just confused about, I guess I'm asking the same question as Justice Gantz. I don't see what it is that you think we should be doing.
I guess, Justice Botsford, what I'm asking this court to do is play its typical referee role. Here we have the town of Kingston applying to the state for funding under Chapter 40R. The other benefits of 40R is that that the town receives bonus payments for every house that's constructed, receives reimbursement for the school costs for children who live in the 40R district. So here, the town applied for approval of its proposed zoning amendment. The result of the approval is the receipt of money. The approval is a precondition for voting on the amendment, and yet the town basically didn't play it straight at the end of the day with DHCD.
Yeah, I think Justice Allen and I are going to ask the same question.
Could you have gone to DHCD and said the town submitted inaccurate, incomplete information, and you need to take another look at this?
It's not in the record, Your Honor, but our clients did do that.
And DHCD
With what effect? No standing, or you lost there?
No response.
Mr. Abbott,
No response from the department?
No response to the letter that we sent advising them of the issue.
Could you have filed an action for declaratory judgment in Superior Court asking the court to take a look at the fact that this was approved without full and complete information?
We may well hear from that, Justice Ireland.
I take it your complaint here, I mean, I'm just reading the land court judge's decision, and I think what she's saying is that there was a very complete review and there was nothing left out, and the application was proper, correct?
No, Your Honor. That's actually not what Chief Justice Shire ruled on this particular issue. If you look at the addendum, page A8, you'll see that the judge says, this determination doesn't end the court's inquiry.
No, I understand
Yes, I'm
that,
sorry.
but on page 7, she's saying, blah, 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 went through extensive and thorough
Right.
impacts and...
You're right, but Your Honor, that's with respect to everything other than
Okay.
the change to the priority species habitat designation. And then what Judge Shire says at that point is that although my clients argued that the application wasn't correct when approved and the town of Kingston knew it, what Judge Shire says is that the only duty she finds for the town to supplement that application didn't arise until after the town voted on the amendment on April 11th, 2007.
Right.
And respectfully, Your Honor, I think that that was error for a few different reasons. First of all, the town was under a duty to supplement because the town submitted the application in July of 2006, at least as late as no later than November 8th, 2006, the town became aware that its application was no longer correct. The town continued to interact and communicate with DHCD regarding other changes to its application, providing more information at least through the end of December 2006. And DHCD didn't approve the application until April 4th, 2007. So the town, knowing that DHCD still had before it an incorrect application in a very material element of it, didn't take any steps to correct it. Now, moreover, Your Honor, the critical date here is not the date that town meeting adopted the amendment. The critical date under a Chapter 40R amendment is the date that DHCD approves the amendment, which in this case didn't happen until August 28th, 2007. And before August 28th, 2007, the town was under a duty to correct its application under both the conditions of the letter of eligibility that it received on April 4th. Condition 6 says that DHCD is giving approval for the town to vote on the town meeting, to vote on the amendment, subject to the condition that it file its annual update, or file an update by July 31st, 2007, setting forth the correct amounts of developable land. The town here never did that. There's also a regulatory provision, 760 CMR 5907A1, that required the town to provide the accurate information with respect to developable land by July 31st, 2007. And finally, Your Honor, Regulation 760 CMR 59054 requires the town to advise DHCD of any changes to its application before DHCD issues that final approval. Here again, that didn't happen until August 28th, 2007. Now, that's four separate duties, two of them imposed by regulations, one imposed by DHCD's letter of eligibility, which was a prerequisite for the town voting on the amendment, and one what I'm calling the common law duty of an applicant for approval, knowing that the application is no longer correct, knowing that the other side is relying on it, and not taking any steps to correct it before.
Where's the harm to you? I'm just really, sounds like a very interesting dispute if it were between DCHD and the town with respect to the appropriateness of the approval process. Where are you in this? I mean, what's your standing essentially in
Well,
this?
as argued in our First Amendment petition, my clients live in properties, at least one of them abuts this locus, this 109-acre district. And what we're talking about here, Justice Cordy, is a development, a highly dense development that could include as many as 730 houses based on the application, 250,000.
Which is exactly what the smart growth process is all about, is to consolidate development around mass transit as opposed to sprawling it all over the place.
Provided that it doesn't imperil the Commonwealth's areas of critical environmental concern. And the Division of Fish and Wildlife Natural Heritage Program has now, as of today, Your Honor, almost the entire property is designated as priority species habitat. But at least as the time of the town adopted the amendment, approximately 50% was. The town didn't give that any consideration, and neither in the town also, by not correcting its application, didn't allow DHCD to understand that fact either.
So can't DHCD just move to get its money back, saying this was all a big mistake?
That's where, Justice Cordy, I think the regulations don't work, because the regulations require the town to advise DHCD of what's going on. The town has to tell DHCD, this is how our application has changed.
So DHCD doesn't know anything about this?
I don't know, Your Honor.
Nothing.
Well,
The town is.
you wrote them.
I'm sorry?
You wrote them, didn't
We
you?
wrote them very early on in the process, and we said we believe that that we understand that the wildlife habitats have changed, and please look into it. It's not part of the record, Judge Botsford, which is why I'm not focusing on it. And certainly DHC, there's nothing from DHCD below. If DHCD was fine with it, Your Honor, I'm surprised that the town didn't supply an affidavit or anything else from DHCD below when we were before the land court on
No,
this.
we have to assume that there's been nothing there. Mr. Abbott, your time is up. Thank you.
Thank you, Chief Justice.
Good morning, Mr. Tallerman.
Good morning, Your Honors. May it please the Court. Jason Tallerman. I'm Town Council for the Town of Kingston. Howard Guggenheim representing the property owners of
Can I
this.
just clarify one preliminary thing? There's no challenge to the standing of these plaintiffs, right? They're the butters.
There was below some concern about standing,
But you haven't raised that on appeal.
that's not an issue here in this appeal.
Okay.
The only issue here in this appeal is what I would consider to be a garden variety challenge to zoning itself, count three.
What about this update requirement? Mr. Abbott says you've had all these obligations in 2006, 2007, 2008. I'll stop where the record ends, and it's never been done.
Well, first of all, the update, I think Mr. Abbott is conflating two statutory schemes here. There is a 40A scheme, which is the adoption of zoning itself, and then there's the 40R scheme, which does require updates. Now, there is a fundamental dispute. It is not a given fact that the Wildlife Atlas does now consume this. For the sake of a summary judgment argument, Judge Shire below in the land court concluded that she had to consider that to be a fact in this case. So the duty to update is in fact in question in this. Now, but it's irrelevant for the purposes of this case. You really don't have to go too much further than Chapter 40R, Section 7B, which should suggest that the updating process itself has no bearing on the underlying zoning enactment itself and cannot operate, even if there's a massive change in the underlying definition of developable land, as an invalidation of the zoning below.
The department can get its money back, can't it?
In fact, I have a big check on the wall, a ceremonial check on the wall that we haven't cashed yet at the town of Kingston.
But they can get their money back.
They
For
can.
instance, if you go through the permitting process, or the developer goes through the permitting process, and not the full amount of units is permitted, but say half as much, such that it gets the grant money gets kicked down to the next lower level. Is the town going to be required to pay some of that back, or can it be?
Well, the town hasn't spent it.
And that's not my
right.
question.
Yeah.
My question is,
Yes. The answer is
the
yes.
town could be required to return some of the money.
Absolutely. But the money is only one part of this.
Yeah. If in the permitting process, I take it it's possible that the Division of Fisheries and Wildlife can issue a permit that will allow this project to proceed at the full number of units.
Yes, even assuming, for the sake of argument, that there is a newly enhanced wildlife habitat area on this, that doesn't preclude development. It just adds another layer of permitting on this particular development.
Mr. Tallerman, I'm looking at 40R 7B, And that all sounds in what the department can do, but how does the department have access to the information that might cause it to be unable to certify, for example, or to conclude that the town is in material non-compliance with the statute?
How might if the town, in other words, did not provide that adequate information? Well, the department itself has created an entire body of technical advice and review and application. They are aware of wildlife atlases. They don't take what we say for granted. They engage in this case, engaged in more of a year of review of the particular property before issuing their preliminary approval, which was the ticket for zoning. They're not without means. Of course, the certification...
So they issue their preliminary zoning, and then there's a change of circumstance.
Yes. And we're under an affirmative duty to then provide accurate certifications. That doesn't mean that they just take that and put it in a file. They have an entire team, I can attest to, that does their own investigations in these things.
So if you didn't add anything about the Wildlife Atlas in 2007 and 8, does that reflect, because put aside for a minute the summary judgment, does that reflect the town's dispute about whether it needed to say anything about that or not?
Well, there's nothing in the record to that effect,
I
generally
just am taking
anyway.
from what Mr. Abbott said, that
But yes,
2007 and 8
there has
were-
been a long-standing dispute, and I want to correct a fact that was made by my brother in the record. The application to DHCD was not incorrect. When it was made in 2006, the atlas was...
I didn't think he was saying it was incorrect. He was saying that's a long date to look at.
No, I believe I did hear a representation. Regardless, I think the point is that when we made the application, the atlas was as represented in that application. DHCD then issues you your ticket to go to zoning. Now, zoning is itself a legislative act. It's not a legislative act by the planners, by the selectmen, by the town's consultants. It's a legislative act by the voters themselves. So they are essentially would be challenging the motives and desires of the voters themselves.
So let's assume that somebody from DHCD is watching this argument and says, let's get a hold of the briefs, and they say to you, we are going to revoke our letter of approval. What happens with regard to the zoning amendment?
It wouldn't affect the underlying zoning amendment. It would disable us from going forward under the program. That is when the judicial review of even that process can start, as we see.
Even though you couldn't have voted to approve it unless you had the letter of eligibility from DHCD originally.
I'm sorry.
The town could not have voted to approve the amendment without getting DHCD
That is correct.
eligibility. But you're saying that now that they've already voted, if that is undone, the amendment still stands, it just doesn't have any legal consequence.
That's right. It is something that we'd be disabled from proceeding under Chapter 40R under, but it wouldn't affect the underlying overlay zoning district.
And therefore, if you manage to change DHCD's mind and again received eligibility, then you'd have both the amendment and the newfound eligibility to go forward.
Yes, and that is, and point in fact, they have copies of the briefs and are quite aware of the arguments.
What do you mean you
post-hearing.
couldn't proceed under Chapter 40R? I take it, let's say you had to refund or you were not entitled to any of the money, any of the incentive money, and the developer said, well, we'll fund all the changes. You could still build that project.
Correct. And in fact, the statute says exactly that. We could proceed and issue all the permits in the world. We just don't get all the other side benefits that are advanced under Chapter 40R and 40S. It is still legitimate, and that's why I think conflating these two statutory schemes is incorrect. This is, at its core, a zoning amendment that exists on its face.
If Chapter 40R did not exist, could the voters of the town have amended the zoning bylaw by adopting this particular
Zoning
verbiage? Yeah.
In fact, that's exactly what they already have done.
No, but I mean that they could do that independent of Chapter 40R.
Absolutely. The process under 40R contemplates this. It contemplates that it's essentially the anti-Chapter 40B. It's an idea to get everyone in the room at the same time rather than at sword point, to do development with a cooperative developer in the right place at the right time, with the right mitigation in place, with the state's help, with the developer's help, with the town's help. That's the process. Without that, it's still zoning, it is still zoning 101. And in fact, here, all we have under count 3, which is the only remaining count that's at issue here before your honors, is still just zoning. So the only issues before you are principles under zoning, stripping away all these other regulations.
So am I correct then that even in the absence of any statute, the town could itself do its own smart zoning amendment?
In fact,
You would say it did?
yes, and in fact, contrary to popular belief, I think towns do that quite frequently. Here, they took advantage of the technical advice of the department to help them move that process along and do it in a way that might also get the town the benefits that Chapter 40R provides in terms of mitigation payments, technical review, some immunities from appeals, and some other benefits under Chapter 40R. All that stripped away, we still have zoning.
I should probably know better than to ask this, but what does it mean, heavily disturbed gravel pit? What does heavily disturbed mean?
Heavily disturbed, it's been extensively mined over the years for the topsoil and the gravel.
So it's like every other gravel pit.
Yes, more or less. I guess it's kind of self-defining when you say gravel pit. It is a tough spot, and for years and years, anecdotally, the town has sought various means of perhaps developing this site, as have the property owners through 40B, through other mechanisms. This was an opportunity, a great opportunity, to take it out of all those somewhat flawed zoning and Chapter 40B processes and put it into something where everyone's a winner. Now, granted, the appellants and plaintiffs don't think that they can be winners here, but they're not without remedy either. They have remedies under the Massachusetts Endangered Species Act where they have possible appeals. They have appeals here under Chapter 40R, which are similar to zoning appeals, with the exception, and I think it's notable here, that they would have to post a bond, a large bond. We'll query whether or not those types of bonds are legal or illegal. I think legal scholars may differ on that. But this, in our view, has always been kind of a backdoor way around that to challenge the zoning itself.
When you say they have remedies under 40R, to challenge what?
An ultimate permit that may be issued. In fact, there has been an initial, the permitting is multi-tiered under 40R. There has been an initial permit granted for this.
What?
That is under appeal by the plaintiff.
And what, permit to do what?
To build the project that is contemplated in the 86-page design guidelines and the very comprehensive zoning here.
Well, that was one of the bases for Judge Shire's decision, that they had opportunities under the permitting process to complain.
Many, many opportunities here. Again, the Endangered Species Act, as well as just what amounts to essentially an appeal of what would be a very big special permit here. But in this instance, this is such a massive project and such a huge undertaking. Doing this through conventional zoning and safeguarding the town's interest in protecting their infrastructure and everything else, everyone took advantage of the Chapter 40R process in a way to get this done. No one ever did it in a way to avoid scrutiny by people who might be injured. We had a 3-day town meeting to pass this. It was not an easy question for the town. There were over 70 public meetings for this project. There's an 86-page design guideline. Under the cases, unless it's not even fairly debatable that the town didn't do their job, you have to uphold it. That's what the long line of zoning cases are. This is a zoning challenge. Without any if the town had failed to undertake any of that analysis, and there is no dispute that the town did undertake that analysis, the plaintiffs might have a point. But keeping our eye on the ball, and the eye on the ball being zoning itself, all of the cases stand for the proposition that it is very difficult to overturn zoning. From the Duran case to the Andrews case to the Simon case, all of the cases speak to this. They even speak to the issue of, is there a substantial relationship to public health and safety and good planning? And I submit to you the record is full of that type of information, and the appellants don't dispute any of that. What they've raised at the end of the day is a red herring with respect to another statute. No one is suggesting for a moment that DHCD might not choose at some point to put the hammer down on the town, or somehow raise a concern over the Mass Endangered Species Act and the redesignation of the Wildlife Atlas. That may happen. It so happens, anecdotally, that most of that atlas is in the gravel pit itself. My experience with zoning as town council indicates that it's probably not going to be a big deal at the end of the day, but the point is there's a process for that. There's a process where DHCD could do it. There's a process where the town could do it. If the applicant had had a concern as to whether or not the town should have filed something that it did not file, I'd submit something else that hasn't been raised yet, and that could be a potential action in mandamus. That does not lie here either. DHCD is not a party. The town is not a party to a mandamus action. All of this arose out of a concern over zoning. The only thing before Judge Shire and the only thing before you is zoning. And the only ticket to challenge zoning is to undercut the town's basic rationale in imposing it. Chapter 40R is itself, per se, just by its own language, underlying the legitimacy of the town zoning. It promotes smart growth. It promotes affordable housing. Here, 150-odd units of affordable housing. It promotes good design, and that's what exactly what the town did. And I think in this case, which is a case of first impression for you, I think it would be the right thing to do to uphold the town's actions here.
Thank you, Mr. Talleyrand.
Thank you.